Strong rebuttal to the DOJ position. The DOJ's argument that federal courts lack authority to enforce a congressional transparency mandate, and that no entity has standing to compel production of the Epstein files is not only legally fragile, it is constitutionally absurd. It effectively asserts that the Department of Justice can unilaterally nullify an act of Congress simply by refusing to comply with it. 1. Congress has explicit constitutional authority over federal records. Article Y gives Congress broad investigatory and oversight power, especially regarding the administration of justice, federal agencies, and public corruption. When Congress passes legislation, the Epstein Transparency Act, directing disclosure of specific federal records, that is not optional. The DOJ attempting to claim that a federal statute is judicially unenforceable is a stealth claim of executive supremacy, not a legitimate interpretation of separation of powers. If the courts lack authority, the DOJ is effectively arguing it can place itself above both Congress and the judiciary. That's not constitutional structure. That is executive branch self-immunization. 2. Courts routinely enforce disclosure statutes. FOIA, the Presidential Records Act, the Federal Records Act, all of them are routinely litigated and enforced by courts. The idea that a transparency statute becomes unenforceable simply because DOJ says so contradicts decades of federal precedent. If courts can enforce FOIA, an ordinary transparency law, they certainly can enforce a congressional mandate as specific as the Epstein Transparency Act. 3. No one has standing. A claim of total unreviewability. The DOJ argument that Rep. Khanna and Massey lack standing might be legally debatable, but the broader claim that no one at all could ever have standing would mean the DOJ can violate any transparency law without fear of judicial review. Courts historically reject that kind of reasoning. Where Congress mandates transparency, public interest standing is wide. Courts do not allow agencies to create unreviewable zones of secrecy by claiming no one can sue us. If no person, no court, and no branch of government can enforce compliance, then the Transparency Act becomes a symbolic gesture with no operative force. Congress does not pass symbolic statutes. The judiciary does not interpret statutes as nullities unless forced to. 4. The DOJ argument undermines its own credibility. The public already believes, fairly or unfairly, that the Epstein case was shielded, mishandled, or selectively buried for years. The DOJ adopting a position that effectively says, no court can make us comply, and no one can challenge our refusal, only validates public suspicion and undermines institutional legitimacy. Whatever the DOJ intended, the optics are a federal agency insulating itself from oversight, a high-profile sex trafficking case shielded from transparency, a law passed specifically to compel disclosure now declared unenforceable. This is precisely the type of behavior that transparency statutes were written to prevent. 5. The executive branch does not get to nullify Congress. The DOJ's stance implies Congress passed a law requiring disclosure. DOJ simply refuses. Courts supposedly have no power to intervene. If that logic holds, then any executive agency can nullify any law that it finds inconvenient. That is not separation of powers. That is not checks and balances. That is executive nullification, and it is unconstitutional. 6. Public interest in the Epstein files is overwhelming and compelling. This is not a standard FOIA dispute. Epstein's trafficking operation involved a documented federal non-prosecution agreement, high-level failures across multiple administrations, cross-border criminal activity, allegations touching public officials, wealthy individuals, and foreign nationals. Courts overwhelmingly endorse disclosure where victims have come forward. Public safety and public integrity are implicated. Government wrongdoing is reasonably suspected. Congress has explicitly required transparency. This situation meets all 4 criteria. 7. An independent monitor is precisely what courts appoint. When agencies have conflicts, it is legally routine for courts to appoint special masters, independent monitors, discovery referees, oversight officers, especially when litigation involves agencies that have conflicts of interest, potential exposure, possible prior misconduct. Given the DOJ was involved in the original Sweetheart deal, there is a plain appearance of conflict. That alone justifies judicial oversight. The DOJ's position, if taken seriously, amounts to a claim that Congress cannot force the DOJ to follow a transparency law. Courts cannot enforce the law even if they want to. No one has standing to challenge DOJ secrecy. The executive branch can bury any records it chooses. That is an untenable interpretation of separation of powers, an attack on congressional authority, and a threat to judicial review. Even more importantly, it is precisely the kind of argument that institutions make when transparency is not merely inconvenient, but dangerous.